the premises license meeting to determine premises license for Artisan in Wargrave. First of all, can I introduce my fellow councillors? I'm Councillor Chris Bowering. I represent Woking Without Ward.
My name is Maura Morgan and I represent Embrook Ward in Wokingham.
And I'm Beth Rowland and I represent South Lake Ward in Woodley.
Thank you very much. So if we move on to those who have the agenda, we move on to page 5. Yep. Sorry, I should have introduced the officers as well. Please.
Thanks, Chair. My name is Neil Allen. I'm the legal advisor to the panel. If you need me ask any questions today, it's purely to assist the panel with their decision. Thank you very much.
I'm Luciani Balker. I'm the clerk to the panel. Shall be taking notes.
Thanks very much. Okay, so let's press on. Did I ask about declarations of interest? Any declarations of interest? No, none of us have any. So that's good. We proceed then. I need to outline the procedure first and reaffirm that only information relating to representations can be considered and that such information must be relevant to the licensing objectives. I confirm that all parties understand this, I hope. The 4 licensing objectives are the prevention of crime and disorder, public safety, the prevention of public nuisance, and the protection of children from harm. Now we'll move on, and I'm going to ask the licensing officer if she will present her report on this application, please. Karen.
Thank you, Chair. Good morning, everyone. My name's Karen Court. I'm a licensing officer in the Enforcement and Safety Service, and I would like to present the report commencing on page 7 of the agenda for you this morning. This morning's hearing is for the panel to consider and determine the application from Hatchgate Holdings for a new premises licence for Artisan in High Street, Wargrave. Members are requested to determine this application because representations have been received and there is therefore the requirement to promote the 4 licensing objectives. The panel have options to grant the application as applied for, to grant with conditions or any other modifications, or to reject the application. And also at this stage, I would just like to mention with regard to the date of the hearing, the 12th of August, just to confirm that this has been set outside of the normal 20 working days limit as set out in the hearings regulations. The hearings regulations, regulation 11, does allow for this to be extended where it is necessary in the public interest to do so. This has been duly authorised by Ed Shaler, who is the Head of Health and Enforcement and Safety. And the reason mainly is in order to ensure that all relevant parties, and particularly the applicant, could be present at the hearing rather than have to adjourn. So that's the reason for the slightly later date than the normal for the hearing. The application was submitted by Hatchgate Holdings on the 1st of June. The consultation ran until the 29th of June. What the applicant has actually applied for is the supply of alcohol on and off sales from 9 o'clock in the morning until 7 p.m. at night, Monday to Friday, 9 a.m. to 6 p.m. on Saturday, and 10 a.m. to 1700 hours on Sunday, with matching opening hours. There was mention on the application of recorded music. You'll probably have seen the comment about DJs in the stage area. That has been confirmed that is not relevant. That part of the application has been withdrawn and there is no request for recorded music on the licence. The premises is described as a ground floor coffee shop, providing on-site dining with alcohol if granted, plus food service, coffee and drink. With consumption on and off the premises and outdoor seating to the rear. They would also like online sales for collection and delivery to be facilitated from the cafe as well. The operating schedule was completed by the applicant. This tied in with the representation from Thames Valley Police, which was agreed and therefore withdrawn on the basis that conditions as detailed on pages 9 and 10 were agreed and would therefore be inserted into the operating schedule if the application is granted. And they cover CCTV, an incident and refusals register, staff training, delivery conditions and age verification requirements. So those conditions would be included on the licence if it were to be granted. The responsible authorities were consulted, the statutory authorities. Of those, Thames Valley Police responded, as I've just mentioned, and the conditions were agreed, and Thames Valley Police were happy with this. There were 13 representations from various persons in the locality. These are summarised on page 11 with the names and the details of the representations. And I'm sure various people will be wishing to address the panel in due course with their concerns. There were also 36 representations in support of the application in Appendix E, and also a petition of 60 signatures in support of the application. And all people who made representations were advised of the hearing today. The panel is asked to take into consideration that any conditions must be appropriate for the promotion of the licensing objectives, must be proportionate and not duplicate any provisions contained in other legislations. And the application should be considered on its own merit based on the merits of the application as submitted. Subcommittee will be taking into account the national guidance, the legislation, the Wokingham Borough Council statement of policy, and will give obviously full reasons. Subsequent to the publication of the agenda, we had a few updates this week to update the panel on. Two people who emailed in support of the application, Verity Holiday and Penny Withers. They confirmed they are unable to attend, but would particularly like the panel to take into consideration their comments. We have an additional submission by resident Phil Warlow, which has been circulated to you all. And the applicant has also asked to be circulated to you various pieces of information, training manual, training diaries and guides to selling alcohol, etc. So that has all been circulated earlier this week. So that updates where we're at with the information that has been received. That covers the report. Obviously, I'm happy to answer any questions. Thank you, Chair.
Thank you. I just got a couple of questions. Just to confirm on page 22, section F of the operating schedule, that text in capitals is removed. Also notice there were no times supplied anyway, which would have invalidated that page, I would have thought. Is that correct?
Yes, that is correct. And I think we could also ask the applicant to fully confirm that that is the case.
Okay, can I check with the applicant?
Good morning. My name is Chris Mitchell from Licensing Solutions. I'm responsible for putting the application in on behalf of HK Holdings. That was actually my error. It was never meant to be on there. And as has been pointed out, there was no hours on it. It wasn't advertised on the premises and it wasn't advertised in newspapers. So it's a non-event as far as any element of application is concerned. And I do apologise about that.
No, thank you very much. That's perfectly okay. We were rather confused wondering where the stage was and why you'd have a DJ, but there we are. The other one was that on section M of the operating schedule, it refers to 28-day period for keeping CCTV recordings, whereas the police are offering 31. I assume that can be updated.
Yes, if you look at the agreed conditions, we've moved out to 31. I have actually got comment on that later on because one of the representations made queried why we were only going to do 28 days when the police wanted 31. But I mean, I can pre-say that now. The 28 days is what is now, if you wish, one of the norms because it's a standard 4-week period. And it's easier to roll over as far as electronic computerization is concerned. Believe it or believe it not, the 31 days stems from back in the old days when I was a licensee and we used to have tape machines and you had 31 tapes numbered 1 to 31. And on the 1st, you put 1 in, and on the 8th, you put 8 in, and on the 28th, you put 28 in, and on the 30th, 30, and on the 31st, the 31st. And so it has evolved. That is why we're asking for 31 days. The police are often asking for 31 days, where in reality, technology suggests that 28 days is better. So we always put down 28 days because it's easier for the operators to do that now because we're not using tapes. But sometimes the police ask for 31s. That's what they want. We asked for 28. But I agreed with Gaps. I agreed with the police licensing officer. It would be 31. That's what we're doing.
Okay, that's lovely. Thank you very much. Yeah, either my colleagues have any questions on Karen?
Thank you, Chairman. On page 23, I assume that page is also deleted, as without music, there won't be any dance.
Dance was never part of it anyway, in that sense. But yes, you're absolutely right. It was my error. When you're making applications in the old system, which is the manual system, which is here, one tends to copy and paste, and I made an error. But on the new system, you have to do everything from scratch. That's my error, and I do apologise.
Anybody have any questions on that report we've just heard? Not. We can move on to the applicant. Would you like to present your application, please, Mr. Mitchell?
Thank you very much. So, good morning. This is the first for me, isn't it?
I'm sorry, did you have a question? Did you put your hand up? Sorry if I didn't see it.
Can I ask a question from licensing? Is that what you're asking?
I was asking if you have any questions of what Karen has just said, with clarification. Do go ahead if you do.
Yes, you asked about. Sorry, you asked about you mentioned that the licensing hours match the opening hours. So the licensing hours that apply for match the opening hours. Yeah, the opening hours from the planning application are not followed at the moment.
Perhaps I could just ask our legal advisor the relevance of the planning application, or planning consent rather.
Yeah, I mean, I think the first thing, Chair, is I'm not sure the licensing officer is going to be in a position to answer that anyway. And the second thing is about planning conditions. What we're talking about today are licensing conditions. They can actually be different. So the license does not have to fall in line with the planning conditions. However, I think issues around sort of compliance with planning conditions and keeping 2 hours, they are matters that could be looked at in terms of the licensing conditions. So in terms of whether the business has kept the hours that's already been set by the planning authority could possibly be relevant. But the key issue here are the licensing conditions, whether this application and any conditions are appropriate in terms of licensing objectives. So in the long way around, that issue could be relevant, but it's not determinative. This panel is not bound by the planning conditions that have been imposed by a different part of the council. Is that helpful?
That's from my point of view, from the public nuisance element,
Yeah.
which is if we're not sticking to hours presently and the opening before permitted times on the planning application, that's a nuisance, and therefore is that not answered?
I think the advice that I'll give to the panel is that those are issues that could be brought up, but they're only issues in terms of the panel's decision under the Licensing Act.
Can I make a point here? What we try and say here is the hours for opening are supposed to be 9 o'clock on a Saturday and 10 o'clock on a Sunday, and the cafe opens regularly at 8 o'clock every morning. And so the point is that whatever the license regulations are they going to stick to those? They're not compliant. So that's the point we're trying to make here. And they're non-compliant. And we've raised this with the planning authorities or the planning department, and we're waiting for some action. But they are regularly opening at 8 o'clock every day.
Yeah, the conditions on the planning consent are extant. This hearing, one way or the other, won't affect that.
I appreciate that, but the point I'm making is that if they've got a planning application approved, but they're not sticking to those plannings. So they have to be considered in terms of how they might operate a license.
Okay, I mean, in fairness to the applicant, perhaps it'd be better if we hear what Mr. Mitchell has to say, maybe clear some of those things up. Okay, if there's no one, if there's no one else, sorry, back to you, Mr. Mitchell.
Thank you, sir. So, as I say, this is the first for me, and in all of my years of applying for licenses and variations, this is singularly the most benign application that I've ever made. Benign. Yes. Because what we're actually, sorry, maybe that's better. I'm so sorry. What we're actually applying for is the hours sought are 0900, as you've heard, until 1900 Monday to Friday, 0900 until 1800 on a Saturday, and 1000 until 1700 on a Sunday. This is an application for a small, independent, family-run coffee house operated by a family who actually live in the village or town, small town, located on the high street, to enable it to add alcoholic beverages to its overall offer, following repeated requests to do so by customers, and to allow for that limited range, as it will be available for consumption off the premises also. Alcohol will represent a very small part of the total business within the existing range on offer, and is seen as a supplementary offer to the existing. There have been no representations from any of the responsible authorities with regard to the grant of the application, save, as you've heard, a holding rep from the police, and the application has been discussed in detail with the police licensing officer, and as you've heard, we've agreed a number of conditions with him, none of which are onerous or restrictive, and were already outlined in our application's operating schedule. The police licensing officer is content for the application to proceed as applied for, with the amended conditions already offered, having been discussed and agreed in detail. Whilst on the matter of responsible authorities, in order to assist the committee, may I raise at this particular juncture that several of the responsible authorities appear to have been engaged by the application process or comment from interested parties to the extent that visits have occurred from the environmental health and planning enforcement, and also a telephone call from noise abatement. And it would appear following comments from local residents. As we will address in a moment, several of the reps have raised issues of abuses of the planning in place at the store, and parking and deliveries and cooking and noise and out of hours activities and rats and waste. Whilst the visits were unexpected, they have perhaps helped clarify several points, and I would hope that I can clarify those to you now. On the 25th of April 2022, an enforcement officer contacted the premises following a complaint about deliveries, but was content that the issue was being addressed and the matter was closed. This was with regard to an earlier morning delivery of milk, which now no longer occurs on the high street. So as far as those deliveries are concerned, that has been dealt with and addressed. Environmental Health visited on the 21st of June regarding a complaint about on-site vermin. This was dealt with at the time, as no evidence was found of any vermin by the environmental health officers. And at the same time, the officers looked at the cooking arrangements and were content with those also, and have left the matter. There was a fan noise issue raised on the 12th of February 2021, and the matter was closed. But on the 29th of June 2022, again, following an anonymous tip, we were told by the council, a gentleman named Tao, and forgive me, I do not have his surname, from the antisocial behaviour unit, phoned again to discuss the alleged noise of a fan from the kitchen, and he confirmed that he would report that he was satisfied that there was no issue to be dealt with, and that we were to consider the case dealt with and closed, confirming that actually he had a job to do and he had to follow it up, which he has done. The planning enforcement officer, would you believe, visited on Tuesday this week and stated that he had never seen such cooking conditions as are applied to the permission before, and that a section 73 should be considered to be submitted immediately to remove them, and at the same time make the case to extend the morning hours on Saturday and Sunday per what we all know as COVID relaxations. In the meantime, he was content that the cooking element of the planning conditions were being complied with. He also agreed with us that this is a high street and deliveries all over the borough and indeed the country are made on double yellow lines, It is a fact of high street life and would be no different here to anywhere else. We would ask that when considering the application and assessing the reps against it, these facts are taken full account of. The reality of the responses from the responsible authorities are at odds with the claims of those making representation against our application. So what is a high street? Well, there's a high street definition in the Cambridge Dictionary that says a street where most important shops or businesses in town are. Another definition is the main street of a town, especially as the traditional site for most shops, banks, and other businesses. And Wikipedia suggests the high street is a common street name for the primary business street of a city, town, or village. And that's where we're at. On this particular high street now are 2 barbers, a hairdresser's, a tattoo parlour, a health and beauty clinic, a butcher, a dentist, another coffee shop, the Bull Public House, which is open, a restaurant called Datoni, which was the White Hart, and as I understand it, may now have planning for some residential units, and the Greyhound pub, which you will hear of in detail with several of the representations that have been made that are actually owned by Hatchgate Holdings. Wargrave used to have 2 bakers, a grocer, a butcher, a chemist, several carpentry shops, a fishmonger, a shoemaker, 4 blacksmiths, a plumber, a wheelwright, a coal merchant, a laundry, and a basket maker. And over recent years, there was a tailor, hosier and breech maker, James and Sons tobacconist, and there was even a W.H. Smith, a Barclays Bank. And of course, at the back of our client's site is the Wargrave Telephone Exchange. I don't know if you know it, but it's quite a large building immediately to the rear of the boundary of the premises. And the back garden, I say back garden, the rear area actually overlooks, or that parking area overlooks our rear area. The owners have generally been overwhelmed by the positive feedback and commentary on local residents for providing a community hub to meet friends and share stories and create memories. And that is really what we're trying to build on here by adding another facility, so that if one is having perhaps a small celebration, a bottle of Prosecco wouldn't be amiss, or maybe a small lager, a bottle of lager, or a glass of wine to go with your Ploughman's or anything else. The sorry, off a second there. Interestingly, the nearest off license is in what was called the village store, which is about half a mile away. We believe this to be a benign application, which under so many other situations will be deemed to be completely so, were it not for a number of local residents or interested persons who've made representations, and that is why we're here before you today. No other responsible authorities have made any representation against the application, including planning, environmental health and pollution control, and none are here before you today supporting the representations made. The premises is acknowledged by the supporters of the application as being a well-run operation, bringing a sense of vigour and community spirit back to the high street. It is also very important to reiterate at this stage that there are no representations from the police or any of the other responsible authorities, because at section 9.15 of the guidelines, it is also clear on this matter. I'm so sorry. And section 915 sets out, I know you know what 915 is, and I know what 915 is. Would you like me to read 915 out? Because there are people here who don't know what 915 says. Would that be of assistance? There are guidelines issued by the government. The last issue, I believe, was 2018, unless I'm mistaken, April 2018. Thank you for that confirmation. And it's a guidelines that every application has to follow as far as those guidelines are concerned. And at section 9.15, it says, it is also reasonable for licensing authorities to expect that other responsible authorities should intervene where the basis for the intervention falls within the remit of that other responsible authority. For example, the police should make representations where the representations are based on concerns about crime and disorder. Likewise, it is reasonable to expect the local authority exercising environmental health functions to make representations where there are concerns about noise nuisance. Each responsible authority has equal standing under the 2003 Act and may act independently without waiting for representations from any other responsible authority. So it is that we're here today to address, as you've heard, not the concerns of any responsible authorities, but rather those of 12 local residents who have made representation against the application, plus Moorgrave Parish Council. As a foil to the representations made against the application, there are 36 representations made in support of the application, with 3 persons here today to give their evidence personally in support of their representation. And there is a petition, as you've heard, with 60 signatories. And there was an opportunity for any signatory to sign against the petition should they have chosen to do so. And the whole petition was only actually in use for under 7 days. So it was quite a quick snapshot, if you wish, of support. Some of the representations made against the application, as you will know, having addressed the bundle before you, are very detailed, but they have to look past some of the detail to identify the relevant elements that you as a licensing committee would normally expect to take account of in an application such as this. Going through the reps individually may take a while, but if I may address the parish council rep first at page 77, the parish council suggests that alcohol sales resulting from online ordering may lead to an increase in vehicular traffic. That's page 77. And inappropriate parking on the high street. Actually, if I can go against that, it has been found that online collections actually speed up the amount of time physically spent in a premises. And parking is not an element in any event that licensing committees would normally be expected to take account of when assessing applications. So we would ask that this element of the rep is set aside. So far as section F is concerned, this was an error on my part, which hopefully you have accepted my apology. It wasn't intentional. But in any event, as the committee knows, actually, you don't need a premises license for music between 8 AM and 11 o'clock at night. So therefore, we would ask that that element of the parish council's representation is set aside also. Turning then to the first rep of Mr. Paddison at page 47. Sorry to jump about, but the parish council's one was a bedrock, shall I say. So at page 47, Mr. Paddison lives at 67 High Street, and he will know that the planning consent already allows trade until 1900, and that this is all the application is for. And we will have to close at 1900, as that is what the planning is for. The fact that Hatchgate Holdings also in the former Greyhound pub some 50 odd metres away is frankly a red herring throughout this application. Some making representations suggest it will open again, and others say it will be turned into flats. But we should all know that it is not so long ago that there were 4 licensed premises along the high street, and that this premise was once licensed as an off license. I'm sorry, my client's premise was once licensed as an off license, I believe under the International Stores banner in its own right. So why should it not be licensed again? Mr. Paddison's concerns over noise must be borne against the carefully crafted nature of the application and the very limited hours sought. So far as the former Greyhound pub is concerned, can I just make a mini statement, if you wish, that it's still currently licensed. I'm actually the DPS on behalf of Hatchgate Holdings. And plans are being laid to upgrade the premises and reopen in the relatively near future. But anybody who has any experience of building and renovating properties will know that timelines and costs have doubled, if not trebled over the last year, so that it is all taking much, much longer than expected. It's regrettable, but there's nothing that we can do at the moment. If I can go on then, Stephen Porter suggests that a license is neither necessary or appropriate, and that the premises is a children's party venue. If this were an issue, then the police and trading standards would both have been involved, and they are not. So we would ask that you set that aside. None of the authorities see that this is an issue. Further, the hours mentioned did not suggest opening until 1900 on Saturday or Sunday, as implied, and the premises could not morph into anything without the explicit consent of the licensing committee by way of variation, as we know. Paul Bozier of 15 School Lane at page 51 cites need, which as we all know is not a consideration for the committee, and then mentions again the former Greyhound pub. So far as deliveries are concerned, all businesses along the high street have the same issue, and it's not likely that sale of alcohol will increase the number of deliveries significantly But again, there is a restriction as to the window of hours that deliveries can be made in as far as the planning consent on this premises is concerned, and which can be enforced by planning authorities and highways if it becomes a real issue rather than a concern of some as now. It is not a licensing matter, as you've already heard. It is planning is a parallel authority. The protection of children from harm is raised again, but parents would not bring their children if there was a loose operation in place. And as I've said, the responsible authorities have raised no issues. Susan Seddon at page 52 lives next door and suggests that the premises are surrounded by residences on all sides. But of course, from your own OS plan, forgive me, I can't remember what the number is. I had it out earlier. But from your own OS plan that is part of the package in front of you, you will see, as we've already discussed, that there is the telephone exchange behind. There is a premise to the left as you're looking into the garden, where there is a tall, solid brick wall, and then a couple of sheds in between that and the garden. And on the right, there is fence panels and plants growing up there. The premises has not introduced early morning deliveries, which again is a planning matter. And in any event, and once again, the possibility is raised of the premises turning into a wine cocktail establishment, creating more noise and disruption. None of the responsible authorities see this as a reality, and it is not fair or realistic that this application will create a public nuisance. Again, the planning hours are as stated, 7 p.m. Monday to Friday, 6 on a Saturday and 5 on a Sunday. To be clear, we are not seeking amendments to this. We are actually sitting the licensing application within the planning authority that already exists. Mr. Hounsell, at page 55, lives on the High Street, I'm sorry, I don't know the number, and appears to be making a representation on behalf of a neighbour of the applicant premises, and also refers to the former Greenhelm pub. As you've heard, there is a brick wall to the left-hand side of the rear garden, and there is a tall fence panel with plants in front of it to the right-hand side. Annie and James Paddison at page 57 live in Church Street and are concerned for their brother-in-law living next door to the applicant premises and those in the flats above who have made their own representation suggesting the peacefulness of his garden has gone and that it will impact on the residents of the flats above. The planning already allows for the garden's use, and there is no likelihood that serving a glass of wine or beer or a glass of Prosecco with a high tea will give rise to any more noise than is experienced now. The former Greyhound pub is then mentioned again, and then the question of need, a recurring theme in a lot of the representations made. Maxine Lucas, at page 59 of 64 High Street, raises the issue of parking, which is not for the committee, as we've discussed, but also raises the issue of opening until 1900 when the applicants already have permission to be open until 1900 during the week. Ms. Lucas also raises litter and then suggests any alcohol sold might lead to issues in the street and congregating at a local bench. I was there this morning and I'm ever so sorry, I couldn't find the bench, but my observation would be that is unlikely. She also raised, and that the responsible authorities would have raised that as an issue if it were. She also raises the former Greyhound pub, which is not germane to this application. Tim Wilson at page 61's precise address unknown, but lives opposite the applicant's premises and welcomes the idea of more trade for Wargrave, and unlike so many others, cannot wait for the day when the high street is busy again with local small businesses, and then goes on to query the need for such an application. Need is not a matter for the committee. He then mentions parking and those issues, and then refers to the former Greyhound pub again.
As far as I know, this is a real alarm, so we're going to have to evacuate. If you follow me, we're going to exit through that door. I'm just going to stop here.